Hello, good evening, and welcome to our front. Now, in recent days, Chief Justice Gertrude Tokonu has faced significant criticism for allegedly petitioning President Akufo-Addo to appoint 5 new judges to the Supreme Court of Ghana. The Chief Justice's petition, dated February 7, 2024, included a detailed 14-page analysis justifying the need for more judges, arguing that the current number of justices at the Supreme Court, 15 in number, is inadequate due to a decreased number of justices from 18 in 2020 and the heavy workload. The analysis highlighted that the Supreme Court requires a minimum of 5 to 9 judges for various jurisdictions, making it challenging to form panels due to frequent recusals. Furthermore, the 595 pending cases and only 2 panels available to hear these cases, delays in justice delivery are inevitable. Supporting the Chief Justice's request is the Attorney General, Godfrey Dami's assertion that increasing the number of justices to 20 is constitutional and essential for effective functioning. Similarly, the Ghana Bar Association's president, Jawe Champon Boafo, has also endorsed the request and recommended additional measures to enhance court operations. Well, the majority in Ghana's parliament has also thrown its weight behind the move by the Chief Justice and the proposal, emphasizing the need for effectiveness in justice delivery. However, the minority in Ghana's parliament and the opposition NDC, in a press statement, opposed the expansion, accusing the President of the Republic of Ghana and the head of the judiciary of colluding to protect current government officials from accountability. They claim the Judicial Council has resisted the elevation of these 5 judges, a decision allegedly overridden by the Chief Justice and the President. The NDC called for the nomination of new justice. They believe that this call is unjust and urged for the decision to be contested. Tonight, we will probe further the Chief Justice's justifications with Democracy and Development Fellow in Public Law and Justice at CDD Ghana and KPMG Professor in Accounting at the Fisher School of Accounting, Professor Stephen Kweku-Asare. He joins me now via Zoom. Prof, you're welcome to our front.
So much, Raymond. How are you?
I am doing well. I hope you are doing well too tonight.
I'm doing excellent. And it's always a good feeling when I get to talk to you.
Brilliant. Now, the understanding is quite clear. There is a massive workload that ought to be dealt with. At least, if anybody peruses what the Chief Justice has put together, with detailed data that can be analyzed by anybody to appreciate and understand this. We will come to these justifications, but already some are saying even the decision to write, identify, and propose these justices on their own is problematic. Where do you stand on that?
Well, very good question. And let me start by saying there are 2 separate issues that should not be conflated. There is a proposal to increase the minimum number of justices on the Supreme Court bench to 20. And then separately, there is a request to the President to name certain specific justices to the Supreme Court. These are very separate issues and they raise very different questions. The first proposal to increase the minimum number of justices is based on evidence that you have described, but I will characterize that evidence as a comedy of errors. Just looking at the Chief Justice's own submission, I counted no less than 5, 6, 7 errors. Everything about that piece of paper is full of errors. And I'm like, how did this even happen? The second proposal to name specific justices is more troubling because that is an attempt by the Chief Justice to insert herself in the appointment process when the Constitution explicitly does not include her in the process, and in fact has an elaborative, collaborative procedure that she is attempting to undermine. In so doing, she's not only undermining the Constitution, she's also undermining the Judicial Council, and she's showing extreme disdain and contempt for the Constitution. In my mind, the second proposal to name specific justices provide grounds for her removal under Article 144 because it exhibits extreme misbehavior and it exhibits incompetence. If the whole Chief Justice does not understand the process by which justices to the Supreme Court are nominated, vetted, and appointed, then frankly, in my humble opinion, she has no business being on the Supreme Court, let alone being the Chief Justice.
Now, I want us to take the two separately. And because you have mentioned the very last one about what happens to the Chief Justice and what you think should happen to her, you want her to necessarily step away from that position because you don't think that by so doing, by her very conduct in this case, she has not exhibited competence in the affairs of the judiciary. I will come to that. But first and foremost, I need to run through the numbers. I need to understand this first because we need to come to some understanding that we need more judges. And pretty much so, she has been quite categorical on it. I am projecting on this screen the details of what she put out there, which would help us understand exactly what's supposed to be the case. So the Chief Justice has been saying quite clearly that in the case of pending cases, there is a significant increase in pending cases at the beginning and the end of 2021-2022 to the 2022-2023 year. Is my reading of this problematic?
Yes, it's extremely problematic. And look, people who deal with data will laugh at what you are portraying. Let's understand what is happening.
Okay.
This is, number one, a truncated distribution. The Chief Justice picks some random years and then she projects some random numbers for us. So what she's saying is, look, if we take a look at 2019 and 2020, when we had 18 and 16 judges, the case resolution rate is respectively 75% and 77%. Okay?
Yeah.
Now, if we continue in 2021 to 2022, and then 2022 to 2023, we see that the number of judges go down to 14 and 12 respectively percent.
Yeah.
And she's arguing that we see that when the number of judges go down, the case resolution rate also goes down to 44% and 37% respectively. Therefore, in their mind, that alone is evidence that the workload has become overwhelming when the judges have fallen under the 16 threshold, so to speak. That's the argument.
Yeah. And why is that difficult to understand?
Well, so many things.
Okay.
I mean, so many things. Number one, everybody can easily see that the 2022, 2021, 2022, 2022, 2023, those are the COVID years. Okay, so those are not normal years for you to benchmark against other years where there was no COVID. COVID alone explains the decline in the percentage that he's showing us. And even worse, look, if you look at 2018, 2019, okay, there are 14 judges. And for that year, they deliberately do not show the case resolution rate. Because if they show the case resolution rate, it will go against their story. In fact, in 2018, 2019, the case resolution rate is 73% with 14 judges. 73% with 14 judges. So by their own analysis,
that would have been the third highest.
That would have been the third highest with 14 justices. And so they exclusively did not, they intentionally did not show the number so that we would only focus on 18 judges, 75%, 16 judges, 77%. And then we have the COVID years. In the COVID years, there are fewer judges and the case resolution rate. By the way, for 2021, 2022, if you do the computation correctly, the number should be 48%, not 44%.
Okay.
So just taking this data and saying, therefore, we need a minimum of 20 justices is just an abuse of data analysis, an abuse of statistics, an amazing misunderstanding of statistics. That is number one. Number two, notice that she also, for whatever reason, compares the case resolution rate, the jurisdiction, and so on and so forth to the United States.
Yes.
I don't know why she does that, because if you read the letter, it is clear she doesn't understand what she's talking about the US system. She doesn't understand the US system at all. For instance, she says that there are 344 federal Supreme Court judges. I mean, what does that mean? Federal Supreme Court judges. No, there are only 9 Supreme Court justices of the United States. And United States is a federation. So each state is almost like a country. It's run, each state has its own parliament, it has its own judiciary, and so on. So you cannot just add up the Supreme Court justice of the states and add it to the federal Supreme Court and say there are 344 federal Supreme Court justices. It would be like saying there are 8,100 federal congressmen, because you go to each state and you add the legislators and then you add them all together. That is a tremendous misunderstanding. Now, there is a sense in which the US federal courts are very different from the state courts. Think about the federal courts as maybe an ECOWAS court that handles matters
within the sub-region,
between the ECOWAS states. And then within each ECOWAS state, they have their separate judicial system. So it will make no sense to say the ECOWAS courts handle only 5 cases, so the Ghana High Court should also handle 5 cases, or the Ghana High Court has a high load. You are comparing apples to oranges, and that is fundamentally a big problem. Now, if you want to compare systems, parallel systems, you can, for instance, take a state in the US and compare it to Ghana. So I just did a random comparison. California has about 39 million people. Ghana has about 35 million people. So population-wise, about the same. The California Supreme Court has 7 members. 7 members. Every year, on average, they deal with about 5,000 filings, 5,000 new cases every year, 5,000. in a $4 trillion economy, 7 justices handling about 5,000 filings in a $4 trillion economy. Ghana, when you look at her data, the Supreme Court of Ghana handles about, on average, 600 cases a year. 600. And they want 20 justices to be handling 600 cases a year. Oh my God. Let's look at Ghana and go to our lower courts. Our lower courts have about 275 magistrates. And these 275 magistrates deal with almost 100,000 cases a year. That is where the bottleneck is. That's where the problem is. And if you had a Chief Justice who understood what was going on, rather than just try to increase the number of Supreme Court justices because she sees a decline in completion rate because of COVID, she will be asking the question, how do we help the lower courts? How do we help the high court? Because those are the tri-courts. Those are the courts that are actually doing all the work. The Supreme Court, like most appellate courts, really deal with questions of law. They hardly try cases. You see them try a case maybe when there's a presidential petition. But other than that, they are mainly dealing with law. People come there, they say, I think the Constitution should be read this way. Another person says, I think the Constitution should be read that way. The Supreme Court can read these briefs and make a judgment without having people to come to the court, and then they adjourn, and then they spend 1 hour talking about whether the affidavit is proper, none of which has anything to do with the constitutional issue in question. So there's a lot of built-in inefficiency at the Supreme Court. When you deal with the Supreme Court, you will notice a lot of inefficiency. And we can reform that and cut the number of Supreme Court justices to 7, have them sit on all cases, and they should be able to do it. The Supreme Court practice rules, the last time it was amended was in 1999. CI 16 promulgated, I think, in 1996, amended in 1999. It's completely obsolete. When you look at that, there are so many unresolved questions as to, who should initiate what in determining the issues and so on. So there's a lot of time that is wasted. And then the court itself creates all kinds of problems. So you would see somebody will get up and he will file a writ trying to injunct the Parliament of Ghana. And the Supreme Court will spend 1 hour asking people, do you have a right to injunct the whole Parliament of Ghana? This is something that should be written one line, dismissed. See Bilson versus Attorney General, because Bilson versus Attorney General already tells us that the Supreme Court only deals with factual disputes. So even if there's a law, and the law is not applied to anyone, you can't just take the law standing by itself and take it to the Supreme Court and say, Supreme Court, interpret this law for me. Laws are interpreted in the context of facts. This is not me saying it. This is the Court of Ghana, the Supreme Court of Ghana, saying it in Bilson versus Attorney General. Why then do we reinvent the wheel and not follow that precedent?
Except that, Prof, it has been stated clearly by the Chief Justice that if the number of judges is not increased, justices of the Supreme Court will have to sit every week on multiple panels, increasing their workload and maintaining the backlog of cases. That is, to her, the crux of the matter.
No, and that's what I've proven to you, that all of that backlog, so-called backlog, is just a COVID matter. If they want to deal with it, I mean, at the very moment that she's filing this case, and we should talk about the way she goes about it, because ideally, the Chief Justice will present a judicial service annual report, and she will point these things, present it to Parliament. The Constitutional and Legal Affairs Committee will invite her, They will ask her questions, and then she can put forward her proposal. You don't meet the president and then discuss with the president whatever it is. You know, if you read the letter says, I'm following up with a previous discussion that I had with you on the number of justices. That means the Chief Justice and the President have been discussing it contrary to the separation of powers that is the bedrock of our Constitution, contrary to the constitutional value of maintaining the independence and the impartiality of the judiciary. If the Chief Justice and the President are talking this way, I mean, I don't know. Reasonable people can ask, well, what else are they talking about? You don't want to put yourself in a position where reasonable people, objective people, not partisan people, objective people can ask, well, why are you talking to the president about increasing the number of justice secretly? Why don't you send it to the people's house, parliament, so that we can all debate it? So that it doesn't mean anything about the workload. More so when she tells you there's a backlog and 2 weeks, they are going to take 2 months vacation. If there's a backlog that they are seriously concerned with, then don't take that vacation, address the backlog. Or even if you take the vacation, because you are dealing with questions of law, why don't you have virtual conferences? It's not important that we all meet in the same room to discuss these cases, just like you have been able to call me on Zoom and we are discussing. The court can meet virtually to, dispose of these cases during the so-called vacation. So I find it to be amusing that you come and you say, well, we need 5 more justices. And by the way, I have the justices that I want. Name these people. And the reason I want them is because we have a backlog and then I'm going on vacation. I mean, it makes no sense. Look, when was the last time the Judicial Service produced an annual report? If you look at their website, it's 2018, but they are supposed to produce that every year. The last Chief Justice to do it was Justice Sophia Akufu. Am I to say that because there's a backlog of annual reports, we should appoint more Chief Justices so that they will produce the annual report? No, they are not doing their work. It's an inefficiency problem. So we should ask them to do their work, not just throw more people at the problem. Throwing more people at the problem is not going to solve the problem because it's not a people's problem. That's why I gave you the example of the California Supreme Court, where they only have 7 Supreme Court justices and they deal with about 5,000 cases annually in a $4 trillion economy. The same all the way around. If you go to New York, they deal with about 2,000 cases. Every year, New York, their highest court is called the Court of Appeal.
It appears you are...
But they solve the case within 34 days, on average.
It appears you are in the minority when it comes to opposition to this particular request by the Chief Justice. First, the Attorney General in a 19-page opinion dated April 29, 2024, believes that the Chief Justice's request is constitutional and necessary for the court's effective functioning. Let me quote a line from that particular statement. It says, given the multiplicity of jurisdictions and the influx of cases at the Supreme Court, increasing the number of justices from 15 to 20 is not only constitutional, but it's essential for speedy and effective justice. This is Godfrey Dame's opinion.
But this is the same argument that we do, and then we have 150 ministers, and then 300 parliamentarians, and then 16 regions, and then 260 districts. Anytime we are not able to solve a problem because people are not doing their work, we try to solve it by throwing more people, and then the work is still not done. When are we going to learn from that the problem is not about the number of judges or about the number of ministers and so on? The problem is finding quality people. You see, when it comes to justice, the quality of justice does not depend on the quantity of judges. It depends on the quality of judges. You need to appoint high-quality judges onto the Supreme Court, onto the Court of Appeal, onto the High Court at all levels, for them to be able to solve this problem that we are trying to solve by just throwing more people at the problem. They'll throw more people at the problem, and no problem will be solved, because I know what the problem is. If they ask me, I can fix that problem within a month, and we would have no issues. So it is not about numbers. And let's go again to Kenya. Kenya has similar. Almost all courts, all Supreme Courts have the same jurisdictions that our court has. It's not that our court's jurisdiction is not unusual. If you go to Kenya, they have 7 Supreme Court justices. But look at the efficiency with which they, for instance, address election petitions. Our first election petition had 9 justices. It took us almost 9 months to resolve. Kenya's had 7 justices. They did it in 21 days. So again, it's not the number of people that you are throwing at the problem. It's the quality of reasoning. I showed you the flaws in the data. You are using such flawed data to implement a policy of increasing the minimum number of Supreme Court justices to 20. By the way, the minimum number of Supreme Court justices is itself fixed by the Constitution. If you go to Article 128, Article 128 says the minimum is 10. So how do you get the Chief Justice and the President meeting, and then somehow they want to take the minimum to 20? What happened to the constitutional minimum of 10?
Maybe they would have
the reasons that I'm telling you.
Maybe they would have listened. Maybe they would have certainly gotten the amendments required so that can be effected. But I'm just wondering how the Bar Association also agrees with this particular request for increase in principle. Now,
the Bar Association would agree.
I've heard them say,
no, they are going to be the beneficiaries from all the inefficiencies.
Oh, really?
When you go to court, we can try a case for 6 years, and you think that is normal?
No,
I mean, cases are tried in days.
I've heard them say,
start trying a case and it's 6 years, and then somebody goes to the appeal court, and then somebody goes to the Supreme Court, and then it comes down, and so on. Is that how you run a system? No. If I want to reform the court system, I'll probably get a bunch of non-lawyers together to look at the system, because the lawyers benefit from the inefficiencies. These are built-in inefficiencies that profit people. Anytime the case is adjourned and you come back, the client has to pay 500 cedis, or the client has to provide transportation, and so on and so forth. So we have to look around the world and say, look, countries that are even richer than Ghana, that have more cases, they have only 7 people solving their on their Supreme Court, and they are very efficient. So what are we doing wrong? And
Prof,
some of the things that we are doing wrong are as follows.
I've heard.
Number one,
Sorry.
Of the time,
okay, before you do the listing, sorry, I wanted to put this in perspective, because you said the lawyers benefit from it. But I've also heard the lawyers say some of you who are opposed to this proposal are opposed to it because you are not actively going to our courts every single day and may not understand the realities on the ground.
Well, I do go to the courts, not just in Ghana, but I've been to the court many times in Ghana, and I always shake my head because I don't know what is going on. I mean, why would a Supreme Court of a country be put on the panel and they start talking about this affidavit is, somebody didn't sign this and that? They are not talking about the law. No. In fact, most of the cases, I'm telling you, because they are legal disputes, you don't even need a court to come and sit down unless there is some issue that they don't understand, and they will tell you, they will write, we don't understand this specific issue, come and explain it to us. We give each side 10 minutes. You explain, they go and sit down, they solve the case. But a simple case like, does the president have the power to let go the Auditor General? This is a very simple question. How can such a question take 3 years? And you are blaming who? I mean, I don't know who you blame, but the Supreme Court itself. Because the Chief Justice has to take such cases and then solve them, get the court to solve them. It makes no sense for a question whether or not the Auditor General has been properly dismissed to take 3 years to solve.
I will now.
So I'm telling you
yes.
that, look, I know what the problems are.
Brilliant. And I now need you to state these problems and those recommended solutions you think can fix them.
Number one, we have to have a more professional registry, okay? So if you go to the registry, I want the registry to be manned by lawyers, very competent lawyers, so they can address many of the problems that require quick addressing even before it goes to the Supreme Court. Number two, every Supreme Court justice should be given maybe 2, perhaps 3 very good clerks that help them address, basic issues, do research for them, and so forth, and so on and so forth. Number 3, each justice needs access to a database, and that access is not something that they should be buying. It should be provided for them at home and at work. Number 4, they need a better conferencing environment so that even when they are sitting at homes, even when they travel, they can have a conference to discuss a case and to solve it. Number 4, all filings should be online. File, you put it online, it automatically goes to them. I mean, I favor all justices, only 7 of them, sitting on all cases, because many of these cases, I don't want a panel of 5 to decide a case, and then, the question is it the real view of the Supreme Court, or is it the view of 1/3 of the Supreme Court? So Supreme Court should speak with one voice in clarity, all members. Okay? So these are basically some quick ideas. One other idea will be to revamp the Supreme Court practice rules of 1996, bring it up to date. It's completely obsolete. It's completely obsolete. And then the last one, in almost all countries that I know of, when there are constitutional issues, because the constitutional issues affect just about everyone in the country, the Supreme Court invites friends of the court to file briefs, what they call the amicus briefs. Our court alone frowns upon amicus briefs. The more amicus briefs that you have, the easier your work becomes, because different lawyers are bringing different perspectives and sharing different insights. And when you read them, you can get a deeper understanding quicker than if you limit yourself to the 2 parties that are litigating in front of you. So these are some of the things that need to be done to address the problems that we have. Throwing more judges at the problem will only compound the problem, because, the more judges you have, the less accountable each judge is, because it feels like, well, there are 20 other people there, they are going to do it.
But Prof,
there's one last problem that I want to talk about.
Okay, very briefly.
Justice Atuguba recently came out, and he was saying when he was on the court for about 6 months, the Chief Justice was unhappy with him, and therefore he did not allow him to sit on cases. You see, this is an example of a case where a Chief Justice freezes a judge from sitting on the case. So if you have that and the cases have a backlog, is the backlog due to the fact that we need more justices, or is the backlog due to the fact that the Chief Justice is only picking certain people and all the others are just there minding their own business? We have to address all these things.
But has it not been fixed with the Chief Justice Wood's automated system? Has it not been fixed with that?
No, I'm talking about the creation of a panel.
Yeah.
Okay. So a case can be decided by 5 Supreme Court justices. Mm-hmm. Somebody has to pick them. But in the Justice Atuguba case, he's saying that he was never picked because he had a problem with the Chief Justice. And I'm saying, How do we know whether that problem is continuing even today? I've known cases where justices were sitting on the case and they have been removed from the case, replaced by other justices. But we never are told why this is happening. These are some of the things that lead to the inefficiency. And if you don't explore these things and keep the minister idea of hire more ministers because we have more problems, or create more districts, or create more regions, for Christ's sake, we need to figure it out. Really,
would it not be simplistic to conclude that the woman who's been at the helm of affairs at the justice delivery system would not know these things, would not have attempted these things, would not have been doing some of these things you actually recommended?
Well, look, let's look at her own data. In her own data, he has 2018, 2019, 14 Supreme Court justices. The conversion rate is 73%. And then she's telling us that in the COVID years, the conversion rate fell. And because of the COVID years, so we should increase the number of Supreme Court justices by 5. And who should pay for that? They will do what they want to do, but I'm just telling you, it's not going to solve the problem. We need quality justices, not more justices.
Now, the other point, though, is the naming of the people she would prefer or is proposing to the highest court of the land. Exactly what's your problem with that?
Well, that's clearly unconstitutional because, as you know, the Supreme Court is a panel of equals. Okay? When they sit, every person has one vote. The Chief Justice does not have a casting vote. Her opinions are as good as any other person's. And the framers of the Constitution, they were fully aware that the Chief Justice is the Chief Administrative Officer, but they did not give her the power to recommend people for promotion because they wanted to preserve that independence of panels. They didn't want anybody sitting on the Supreme Court to feel he or she owes her position to the Chief Justice's recommendation. And that is what he has done does. It immediately breaks the whole structure that has been set up. We want our court to have a neutral environment, and that's basically why we don't want the Chief Justice to be involved in such promotions because we don't want internal politics and power struggles. When she named the 5 people, what did she say? For one person, he says, I'm naming this one person because this one person has done a good job at the ECOWAS court. And then I'm naming these 4 people because of their courage, their conscience, and so on and so forth. Well, are these the only 4 or 5 justices that meet this criteria? Who else was considered by the Chief Justice? Look, if you ask me and you want to promote somebody from the Court of Appeal, there's nobody who is more qualified than Sir Dennis. So why is Sir Dennis not there? I mean, you start doing that and you, the Chief Justice, you are going to have a war within the judiciary because you are now playing favoritism. You want a panel of 5. A panel of 5, they sit on a case. So basically, you are asking the president to give you 5 justices, and then you also have the power to constitute panels. So if there is a case that you want a certain outcome, you go to the people who owe their position to you. That is completely undermining the judicial system that we have set up, the independence that we have set up for our judiciary. There's also several problems. We have this notion of separation of powers. Separation of powers. We want the executive to do certain things. We want the legislature to do certain things. We want the judiciary to do certain things. Everyone should stay in their lane. You, the Chief Justice of all people, should know that unless you are given a role, you shouldn't go and do it. Because once you do that, you are undermining the core value. You are upsetting the basic structure of the Constitution. Third, when you do these things, it raises questions about whether or not you even understand your position, whether or not you are fit for your position, because these things should be done by a rookie who doesn't understand the court process. But you were recently nominated, and the process that you went through had nothing to do with the then Chief Justice. So why is it that all of a sudden you want to become a one-man show, the same person who is nominating judges, the same person who is constituting panels, the same person who is reconstituting panels? That's a kangaroo court. You are trying to give Ghana a kangaroo court that undermines public confidence. The public is expected to have confidence in the judiciary. If the public notices that the structure that we put in place to appoint people is being undermined by no person than the Chief Justice, they will automatically lose any confidence in that system. And then where are we? So I believe that on balance, the letter that he wrote nominating the 5 justices creates so many problems and raise serious questions about whether she has conducted or whether she has engaged in stated misbehavior that is used in a constitutional sense, and whether she's incompetent, again, that is used in a constitutional sense. In other words, Article 144 says that if the Chief Justice engages in stated misbehavior and or is incompetent, then removal proceedings must be triggered. And I believe the evidence that we've talked about, obviously there are other things that we've not talked about. So for instance, we have the Chief Justice by herself issuing practice directives when the Constitution clearly says it is only the Rules of Court Committee that can issue practice directives. When a person shows such consistent and utter disdain for simple constitutional commands that are meant to constrain her, then I believe she must be removed. And it saddens me to say that because I really like the Chief Justice. I really like the Chief Justice. She's, from Wesley Girls, and I like girls from Wesley Girls. She was on campus when we were fighting the PNDC against kangaroo courts. She fought. She was part of the system that fought the kangaroo courts. And so I'm quite shocked that she will come in and she will not be modest and she will be doing all these things that interfere with the proper administration of justice. Justice Redu did not do that. Justice Acquah did not do that. Justice Sophia Akufu did not do that. Justice Georgina Wood did not do that. Justice Ani Yabua did not do that. And all of these people I'm mentioning are Chief Justices. They did not do that. So why do you all of a sudden come in and you think you are the smartest person around? You start nominating people for the Supreme Court. You think you are the smartest person around. You start inviting the president to increase the minimum. The president has no power to increase the minimum. If you want to increase the minimum, that's a constitutional amendment. That belongs to Parliament. It doesn't belong to either the president or the Chief Justice.
But is she bad from suggesting that something of that sort should happen as the head of the judiciary? Is she bad entirely for making mere suggestions, be it at a forum, in a letter, or even if this were an academic letter?
Yes, she is. You see, this is one thing that people don't understand. They will read the Constitution and they will say, oh, well, there's no explicit bar, and therefore she hasn't done anything wrong. Now, if you read the Constitution, there's no explicit bar that the president cannot suggest some names to the Chief Justice to put on a panel in a certain case. You won't see that in the Constitution. But that is not how to read a Constitution. You have to read a Constitution with the common law. I mean, what problems were the constitutional framers trying to solve? What are the values of the Constitution? What are the principles of the Constitution? And you also have to read the Constitution with an understanding that when it comes to power, it's limited. Rights are unlimited. If something is not forbidden, then we can do it. People, that's a right. But when it comes to power, if it is not granted, then it cannot be done. So any duty bearer, they go to their warrant and they say, what am I allowed to do? And those are the things that you're allowed to do. If you are not allowed to name justices and you go on using the letterhead to name justices, you are interfering with the operations of the Constitution. The fact that you and I can do it as ordinary citizens does not mean the Chief Justice or a duty bearer can do it. Let me give you a quick example from Kenya. In the Kenya Constitution, it says the Constitution can be amended or reviewed or whatever by a certain number of people signing a petition. Kenyans gathered 5 million signatures to review their constitution or to amend their constitution. The problem was that that idea came from the president. That idea to gather the signatures came from the president. The Kenya Supreme Court rightly said the president's involvement made the whole exercise unconstitutional, even though there is nowhere in the Constitution which says the president cannot do it. The fact that the president was not named means the president cannot do it. That is how people should read the exercise of power. If you go search in the Constitution for a list of things that duty bearers cannot do, then I mean that's not how to read a Constitution. Let me put it very nicely.
I get your point, except that when you strongly say that, oh well, she should be removed from office. I mean, some will say that it should be clearly stated that this is not to be done by her. And a mere suggestion, a mere proposal cannot come from her.
It's clearly stated that if you misbehave, you can be removed.
And the proposal stated that if you are misbehavior,
you can be removed. How does a competent chief of the Supreme Court or chief of the justice system starts naming people and creating friction in the judiciary? Now, if I'm a judge, if I'm a judge of the Court of Appeal and I wasn't named, I'll be happy. I'm going to ask, well, why didn't he name me? Why is he naming these people? Why is he playing favoritism? So you've lost some of the bench by this singular action. That's why you have to think about what you do. You've lost part of the bench. You've lost part of the population. You, the Chief Justice, you have, the people, the justice system. You are presiding over a system. So you have to avoid anything that gives the hint of favoritism. Look at our politics. Our politics has become patronage. Everybody has a godfather. If you don't have a godfather, you can't get contracts, you can't get a school, you can't get scholarship. That is what will happen when we start allowing the Chief Justice to nominate people for promotion. Then people on the bench will, instead of doing their job, they say, hey, let me write this thing so that I'll catch the eye of the Supreme Court. And the moment you do that, you have defeated the structure that the framers had in mind. And I mean, after all, they said the Chief Justice is the Chief Administrative Officer. So why didn't they just say, well, name the justices to the Supreme Court? They didn't say that because of the values of independence. They wanted to avoid patronage. They wanted to avoid favoritism. And they wanted the person who makes that decision to be accountable. That's why we have a president doing it. And that's why we have a parliament vetting. If we are unhappy with the president's decisions or parliament's decision, we go and vote against them. The Chief Justice has life tenure as long as she's behaving well. If she's not behaving well, then she's removed. So we don't want somebody with life tenure to be then appointing other people with life tenure so that they can go and sit on the court and then form some kind of clique doing their own agenda. And that's why this is very dangerous. To me, it is the sign that we have an imperial Chief Justice, a justice who can appoint or at least influence strongly the appointment of people who then can decide what court panel sits on what cases. And if she doesn't like what you are doing, she can remove you from the case and replace it with other people. I mean, again, if this is not an imperial Chief Justice, I don't know what is.
In all fairness, the appointment has not happened. We are still at the stage where she had just written a letter proposing people. We know that for a fact,
yes,
right?
Of course, of course. I'm telling you, the reason why the appointment, the letter, the suggestion should not even happen. Because one other problem is you write that to the president, and the president says, oh, let me do it. The Chief Justice wants it. So that when I want something, she can also do it for me. That type of perceived, I mean, there's so many things wrong with this thing. It really breaks my heart that Justice Tokonu has found herself in this dilemma. And it is with pain that I'm saying she should be removed, because I don't say that lightly. I like her. I don't say that lightly. But the Constitution is the document that governs us. And if my friend, my sister, my brother, whoever you are, if you violate it, I'm going to aggressively suggest that you be removed, because the Republic is more important than any friendship or party and so on that we belong to. She should never have done that.
And for the avoidance of doubt,
allowed that to go unpunished, then we have ruined our court system for a very long time to come.
And for the avoidance of doubt, your reference is to 1442, which says that the other Supreme Court justice shall be appointed by the President, acting on the advice of the Judicial Council in consultation with the Council of State and the approval of Parliament. This, you say, she has no role in there as an individual. So that's why she should have been involved in the first place. That's all.
Exactly, yeah. She has no role there. You see that the Judicial Council advises, but she's one of several voices on the Judicial Council. So you cannot preempt the work of the Judicial Council by you going to nominate or suggest names to the president.
We need to wrap up this conversation, and I'll be taking final words from you, Prof. The final words, they are in the direction of the democracy project's what they call compilation of the trust in institutions over the period. And if you look at that table, it appears that trust in not only the courts, but also the police and the Electoral Commission is at an all-time low. If you are just concentrating on the court, how do we fix that trust problem?
Well, you know, look, just the courts have one rule in society. They have to administer justice. They have to do it in a fashion that is speedy. They have to do it fairly. The judicial system must be accessible. They have to communicate to us in a language that we understand, and so on. If they want to rebuild trust, these are the things that they have to do. They should not look at who the plaintiffs are, who the defendants are. They should just do the law. They should just follow the rule of law. If they follow the rule of law and they act quickly and so on, people will trust them. On the other hand, if I send a case to the court about the Auditor General being removed and it takes 3 years to resolve that, and another person takes a case to the court about a similar issue and you resolve that in 1 week, you can bring all the pastors in the world to pray for us and still there will be no trust in the system. The trust that we have in the system is a function of what the judges do.
I'm most grateful to you, Prof, for joining us from your base in the USA. Professor Stephen Asari is a Democracy and Development Fellow in Public Law and Justice at CDD Ghana, and also a KPMG professor in accounting at the Fisher School of Accounting. Many thanks to you also for joining today's edition of UPfront.
Thank you.